Hi, this is the second lecture of Legal Medicine and Medical Jurisprudence. Today we talk about medical evidence. I am Dr. Duresfe Itagayuna, and I will be your faculty for this topic. Evidence, as presented in court, is covered by the Rules of Court. Section 1, Rule 128 says that evidence is the means sanctioned by this rule of ascertaining in a judicial proceeding the truth respecting a matter of fact. Section 2 of the same rule states the rules of evidence shall be the same in all courts and on all trials and hearings, whether civil or criminal. Rule 128, Section 3 of Rule 128 says, evidence is admissible when it is relevant to the issue and is not excluded by this rule. Section 4 says, evidence must correspond with the substance of the issue, and therefore collateral matters shall not be allowed except when they tend in any reasonable degree to establish the probability or improbability of a fact in issue. The components of evidence include that it is a species of proof, it is legally presented at the trial and accepted by the court, it is an act agreed upon by both parties through witnesses, audio records, documents, concrete objects, and the like, for the purpose of proving what was previously presented to the members of the court. In a judicial proceeding, medical evidence is the means, sanctioned by law, to ascertain this truth with respect to a matter of fact, where scientific medical knowledge is necessary. It must be relevant to the issue again and not excluded by the rules of court of the Philippines and must correspond to the substance of the issue. These are the forms of medical evidence: real, testimonial, experimental, and documentary. Autoptic evidence are those that are presented to the senses of the court. Section 1 of Rule 130 of the Rules of Court, entitled View of an Object, states that whenever an object has such a relation to the fact in dispute as to afford reasonable grounds of belief respecting it, such object may be exhibited to or viewed by the court, or its existence, situation, or character proved by witnesses as the court in its discretion may determine. This is not limited to that which can be known by the sense of vision, but extended to what is perceived by the senses of hearing, taste, smell, or touch. But there are exceptions to this rule. One is indecency and impropriety, or obscenity, or indelicacy, and the second, repulsive objects and those offensive to the sensibilities. Such are indecent acts or remarks. A physician may be placed at the witness stand to answer questions propounded to him by the counsels of parties or by the presiding officer of the court. Testimonial evidence is given orally in open court and under oath or affirmation. A physician may be an ordinary or an expert witness. There are three major differences between the two. The former is a witness of fact and gives evidence of those facts which are under inquiry. The expert witness supports his evidence by the experiments which have been performed by him in the absence of the opposite party. The ordinary witness is available to the opposite party for veracity, such as truthfulness, accuracy, correctness, faithfulness, fidelity, reputability, honesty, sincerity, trustworthiness, reliability, dependability. And three, the expert gives the rules and reasons for which support his opinion. For example, if a medical expert gives an opinion on symptoms or after effects of a particular poison, then he may also refer the book in support to his opinion, based on which he has opined, suggest, comment, remark, declare. The ordinary witness gives evidence of what he has perceived by his senses. The significant difference between these two types of witnesses is personal knowledge. An expert may use their knowledge or skill to draw conclusions, whereas an ordinary witness can base their opinion only on what they observe. A medical witness may be required to perform certain experiments to prove a certain matter of fact. This experiment, however, must not be offensive to decency, sensibilities, and propriety. Any written evidence presented by a physician in court which is relevant to the subject matter in dispute and not excluded by the rules of court is called documentary evidence. This may be in the form of 1. Formal written reports, 2. Written opinions, 3. Medical certificates, 4. Depositions, or 5. Dying declarations. As would be expected, evidence that is in the form of a tangible object, such as a firearm, fingerprints, rope purportedly used to strangle someone, or tire casts from a crime scene, is considered to be physical evidence. Physical evidence is also known as real or material evidence. It can be presented in court as an exhibit of a physical object captured in still or moving images, described in text, audio, or video, or referred to in documents. The Latin term corpus delicti refers to the principle that there must be some proof that a crime has been committed before a person can be convicted of having committed that crime. In Western law, the term has also been widely used to refer to the object upon which the crime was committed, meaning a body, in the case of a murder, which itself proves the crime was committed. Associative evidence is something that may associate a victim or suspect with a scene or with each other, such as personal belongings. At a crime scene, there are often tiny fragments of physical evidence such as hair, fiber from clothing or carpeting, or pieces of glass that can help tell the story of what happened. These are referred to as trace evidence and can be transferred when two objects touch or when small particles are dispersed by an action or movement. For example, paint can be transferred from one car to another in a collision, or a hair can be left on a sweater or under the nails in a physical assault. This evidence can be used to reconstruct an event or indicate that a person or thing was present. There are many types of evidence that, while not admissible in court, can be valuable to an investigator trying to reach a conclusion in something like a workplace investigation or other non criminal investigation. And even some evidence that is not admissible in its own may be admissible in conjunction with other types of evidence. While not the kind of evidence used in court, the analogical evidence can be useful for increasing credibility by drawing parallels when there isn't enough information to prove something in a workplace investigation. Analogical evidence uses a comparison of things that are similar to draw a comparison, similitude, or affinity. Anecdotal evidence isn't used in court, but can sometimes help to get a better picture of an issue. The biggest problem with this kind of evidence is that it is often cherry picked to present only the anecdotes that support a particular conclusion. This should be considered with skepticism and only in a combination with other, more reliable kinds of evidence. Character evidence is a testimony or document that is used to help prove that someone acted in a particular way based on the person's character. While this can't be used to prove that a person's behavior at a certain time was consistent with his or her character, it can be used in some workplace investigations to prove intent, motive, or opportunity. Also known as indirect evidence, circumstantial evidence is used to infer something based on a series of facts separate from the fact that the argument is trying to prove. It requires a deduction of facts from other facts that can be proven, and while not considered to be strong evidence, it can be relevant in a workplace investigation, which has a different burden of proof than a criminal investigation. Digital evidence can be any sort of digital file from any electronic source. This includes email, text messages, instant messages, files and documents extracted from hard drives, electronic financial transactions, audiovisual files, video files, audio files. Digital evidence can be found on any server or device that stores data, including some lesser known sources such as home video game consoles, GPS, sport watches, and internet enabled devices used in home automation. Preserving digital evidence is also challenging because, unlike physical evidence, it can be altered or deleted remotely. Investigators need to be able to authenticate the evidence and also provide documentation to prove its integrity. Exculpatory evidence can exonerate a defendant. Usually, in a criminal case, prosecutors and police are required to disclose to the defendant any exculpatory evidence they find or risk having the case dismissed. Forensic evidence is scientific evidence such as DNA, trace evidence, fingerprints, or ballistic reports and can provide proof to establish a person's guilt or innocence. Forensic evidence is generally considered to be strong and reliable evidence and alongside helping to convict criminals. Its role in exonerating the innocent has been well documented. The term forensic means for the courts. Its use in the workplace investigation is generally limited to serious cases that may end up in court. Hearsay evidence consists of statements made by witnesses who were not present at the time of the crime or activity in question. While hearsay evidence is not admissible in court, it can be relevant and where the burden of proof is less robust than in a court. Meaning on its first appearance, prima facie evidence presented before a trial is enough to prove something until it is successfully disproved or rebutted at trial. This is also called presumptive evidence. Evidence that uses numbers or statistics to support a position is called statistical evidence. This type of evidence is based on research or polls. Now, there are two kinds of evidence necessary for conviction. One is direct evidence. This is the evidence that proves the fact in dispute without the aid of any inference or presumption. The evidence presented corresponds to the precise or actual point at issue. That's direct evidence. On the other hand, circumstantial evidence is that which the proof of fact or facts from which, taken either singly or collectively, the existence of a particular item in dispute may be inferred as a necessary or probable consequence. The degree of proof required in the court of justice varies. For civil cases, only a preponderance of evidence is required. Preponderance of evidence means the greater weight of evidence that will outweigh the evidence of the other party. It means that the evidence adduced as a whole by one side is superior to that of the other. However, for criminal cases, there should be proof beyond a reasonable doubt that which is presented by the evidence. The defendant is entitled to an acquittal unless his guilt is shown beyond a reasonable doubt. Thank you very much for your kind attention.